Hi, I'm Russ Bleemer. Welcome again to CPR's YouTube channel. I edit Alternatives to the High Cost of Litigation for the CPR Institute, the host. And I'm joined again by our fellow arbitration court watchers and analysts. Fellow New Yorker Phil Lurie Jr. is here. He's from New York's Lurie Law Firm. Our two friends from Dallas, Angela Downs, who's professor of practice and assistant director of experiential education at the University of North Texas, Dallas College of Law, and also Rick Faulkner, an attorney, arbitrator, mediator. We're back here the week of November 11th. It's a return. We last rounded up the 2023-2024 Supreme Court arbitration cases after Memorial Day. There were three of them then. You can see the links here for that discussion. But there was an added bonus discussion that sort of almost overwhelmed the Supreme Court work. It was on our minds the cost benefits of arbitration. Specifically in that video at the end of May, we looked at two big arbitration awards that Walgreens was facing, and we previewed a decision in which ultimately in the summer, Samsung dodged a big bullet when a mass arbitration it had imposed on consumers was unimposed by a court. It relieved Samsung of the requirement to pay tens of millions of dollars in filing fees when it turned out that the claimants didn't adequately establish their bona fides. Again, that video is here. The full details on those cases are on CPR's YouTube channel. But to summarize, this panel looked at those cases and agreed appellate review was inevitable on mass arbitration, and it's probably going to get to the Supreme Court. Well, it didn't take long. Here we are again. We're reconvened on that point. The costs of commercial arbitration with the specific frame here, again, mass arbitration. This is the Heckman versus Live Nation case. It was decided in the Ninth U.S. Circuit Court of Appeals about 2 weeks ago on October 28th. The panel upheld the U.S. District Court ruling that the mass arbitration program, where individuals were required to arbitrate their comparatively low value disputes with Live Nation's Ticketmaster unit, was both substantively and procedurally unconscionable. The ticket buyers could take their antitrust claims to court. Now, there's concurring language in that case that calls for mass arbitration programs in their entirety to be into question. And the majority decision focuses on and seemingly restricts it to the rules that were presented there. The answer to all of these court disputes on arbitration, as this terrific panel has provided us before in any form on these videos, it's always been better drafting. In this case, the Ninth Circuit handed it to us and handed it to the public as well. It blasted the vagueness and even the spelling in the rules from the New Era ADR firm that provided the rules for Live Nation's program. Less than a week later, the principals from the New Era firm fired back on law.com and said that the concerns had long been addressed and the Ninth Circuit was way off base. We have a link down below to Heckman versus Live Nation and a report that we did on it on the CPR Speaks blog. We also have New Era's ADR program report response linked as well. A request for extension of a time to file a request for a rehearing in the Ninth Circuit in Heckman versus Live Nation was denied by the panel that decided it. The time for rehearing at this recording has expired. I've asked both sides about a rehearing or a cert petition, but there's been no response. There is much time to run before a cert petition would be filed in the Supreme Court. I believe it's 90 days in this instance. So we'll be hearing more about it. Now, there's lessons out there on Heckman versus Live Nation already. The bellwether cases and the batches and the mediation steps, if you have any familiarity with the mass arbitration rules and protocols and all, that's what they focus on. I'll shout out to Gibson Dunn Law Firm. They did a CLE on handling mass arbitration in the law in this current environment, but there may be bigger issues here right now than just the how-to. Unconscionability, which is a focus of Heckman versus Live Nation, may be a California thing. It may be limited to these now apparently dated New Era mass arbitration ADR rules. We'll see about that. As we saw in Samsung, though, unquestionably courts generally have a positive view of these mass arbitration programs, and the criticisms of the programs that we've seen in courts is really just refinement and growth. It's an answer and a reaction to the flood of claims. I want to ask our panel, what is your most important takeaway from Heckman among the court's reasoning? But I also want to focus in on the potential effect of the nuclear concurring opinion language. This was a the most recent appointee on the Ninth Circuit panel, Circuit Judge Lawrence Van Dyke. Do you think his concurring opinion might have legs? We're going to talk about the details of it. This concurrence takes the process of mass arbitration right out of the Federal Arbitration Act, using the Supreme Court cases themselves to make that argument. Is that an argument with enough steps in this opinion to use against drafting and arbitration rules, to argue that the resolution process that you're confronting is just so far afield that it isn't FAA arbitration at all, no matter what you call it? What do you think about this opinion, this concurrence, Phil Lurie?
Well, it's the concurrence, and it's also the independent and alternative ruling of the majority opinion. And all three judges agreed that this mass arbitration program was not arbitration as envisioned by the FAA back in 1925. So, arguing from that basis, the all the judges agreed that the FAA, at least alternatively, that the FAA could be deemed not to apply to this arbitration scheme. And the standpoint of the concurrence, that judge said, Judge Van Dyke said, this is it's the kind of thing where it's the kind of thing where the this scheme, if the scheme is labeled or referred to arbitration, that does, and it doesn't mean it's necessarily governed by the FAA. And if it's not governed by the FAA, then there's no preemption, of allegedly conflicting state law. And what we had before the concurrence in particular was that the concurring judge said that the Discover Bank rule, which was thrown out by Concepcion, would actually not be preempted in this case because the arbitration scheme was not the kind of bilateral arbitration scheme that was envisioned by the FAA. So one initial question that all this raises is, does this conclusion make any sense? It's, as you said, we're kind of, we're looking at, we're so used to Concepcion and everything else, and we're looking at bilateral arbitration situation where somebody's trying to say that that class arbitration should be approved or not. But here, what you're dealing with is something very different. You're dealing with a situation where the parties are going out of their way to opt out of bilateral arbitration and create a situation that's specifically designed to deal with mass claims in a way that the court found to be unconscionable. So I think one thing we're going to see a lot of litigation about is, the concurrence that there must be an outer boundary to the type of arbitration subject to FAA obstacle preemption. Inside that boundary, you have laws that are preempted because they interfere with fundamental attributes of arbitration, like the Discover Bank rule. Outside, you got agreements that, even if labeled arbitration agreements, go beyond the degree of deviation from bilateral norms of traditional arbitration. The question is, what does that mean, that they, to the extent that they go beyond the degree of deviation from bilateral norms of traditional arbitration? It's kind of a foggy standard. I mean, in this case, it's pretty clear that the mass arbitration scheme was certainly not a bilateral arbitration scheme, and it was designed specifically to remove the parties from that kind of an arbitration scheme. And so what we're going to be seeing, I think, is courts looking at what kinds of arbitration agreements go beyond this degree of deviation from bilateral norms. As I said, it's pretty easy to conclude that New Era's scheme was so deviated, but does that mean that other mass arbitration schemes will suffer the same fate? You have lots of different providers. You got JAMS and AAA. They've all have their own mass arbitration schemes. Are they covered by the FAA? This is, and I think you have to look at each one and ask yourself, is it, can you argue at least that it's at least based on or derived from a bilateral arbitration scheme? And you may have, I think what it's going to probably really boil down to is the fairness of the scheme, because if, in a typical mass arbitration, the presumption is you got, you know, hundreds of thousands of single arbitration cases, and you have to, the idea is how to deal with them together. But, so you can argue that, as to each individual case, that's kind of and it is a bilateral arbitration. So I think the focus will be on what the mechanism that is to be used to efficiently resolve those claims, and whether, in this case, of course, the mechanism was just completely unfair, and
Yeah,
for various reasons.
to be clear on that, Phil, both the U.S. District Court and the Ninth Circuit opinion analyzed that fairness provision in the traditional way the courts, and particularly the California courts, do, procedural and substantive unconscionability. And they looked at that language and said it was so vague as to how the precedent case would be applied that this was not fair and unconscionable. I want to switch over to Professor Downs, because on that point, the court took a real consumerist viewpoint, without a doubt.
They did. And I think, Phil brings up such a good point. The court in Heckman says that this case, and particularly Ticketmaster, it's more than a mere garden variety contract of adhesion. And they really took a hard and fast look at the issue of procedural unconscionability, and really looking very closely at how California courts look at that, focusing on factors of oppression and surprise, with oppression arising from inequality of bargaining power that result in no real negotiation and an absence of meaningful choice, and then surprise, which is a function of the disappointed, reasonable expectations of the weaker party. And if we just take those two terms, oppression arising from the inequality of bargaining power, if you think about it, when a consumer decides that they're going to buy a ticket to a show from Ticketmaster, it's a take it or leave it. And the court actually focuses in on that, because either you buy the ticket with all the surcharges and all of the other taxes and other things, or you don't go. There's no other way around that. Um, and with the surprise, it's a function of the disappointing the reasonable expectations of the weaker party. So if you are the consumer, you're stuck. You have no other recourse. You either buy the ticket or you don't participate. And I think the court really recognizes that. And the court says that they recognize that, but there's no greater uh, relationship with a greater power imbalance than that between this defendant and its consumers,
Now the
because it's
court,
it's an all or nothing provision.
now the court was highly specific here about these new era rules. As noted, new era has said their rules have changed, and this is simply not current. It's not like that. Are there any indications that other providers have these sort of concerns? The court didn't do a comparison, so.
Well, I mean, and I think it's interesting that this case, although the court is really looking to um, listen to the small guy, the consumer, it's not a consumer case. It's
Mhm.
a Sherman Act antitrust case, which I think is a very smart way to look at this kind of issue. And so the court is really looking for ways to shore up and support consumers, because they know that there are no other possibilities.
Yeah.
As far as what they're going to do in other cases, I think it's really yet to be seen. Is this something that um, we'll I guess we'll kind of, as we say, wait and see.
Yeah,
But
yeah, I'm
I
sorry.
don't think we're going to have to wait long, y'all, because this came up at the Federalist Society General Council's meeting here in Dallas in May, and pretty uniformly, and we're not allowed to say who said what for attribution. The uniform attitude was the mass arbitration rules of the AAA and of JAMS are a total failure. They are not attractive. They still cost too much. New Era has changed its rules, and it's not doing things in anywhere near this particular manner. But I think there's a big point in this concurrence that we really haven't touched on, which is Judge Van Dyke went out of his way to do two things. One, say unconscionability applies to the delegation clause too, and the courts must decide that. In many of the other cases where there have been delegation clauses, Airbnb is a great example. Those have been through the incorporation of the applicable arbitration rules. In Airbnb, it was AAA, Rule 7. JAMS, I don't know the rule number. I think it's 11. And no consumer lawyers were invited to participate in the drafting of those rules. The unconscionability is there. If you look at many of the click wrap contracts, what do you see? A hyperlink that may or may not work that says, oh, here are the terms and conditions. You have to click on that. Then it may mention arbitration, and it may say somebody's rules. You've got to go click on that. And then if and only if you understand what jurisdiction and delegation are, can you figure out what you're agreeing to. Now, the four of us are perfectly happy with that. We understand these arcane terms, but even Justice Scalia said that arbitrability can be so arcane that it really is not something that should be presumed by the courts. And I think Judge Van Dyke was going right back to what Justice Scalia said. And when you look at what the U.S. Supreme Court has been doing in constitutional cases, I think they're giving us a pretty clear indication that if this case goes up to the U.S. Supreme Court, there are going to be real issues. Warren Postman's firm has been on the cutting edge of a lot of these, and he's done a very interesting job. I don't know about y'all, but I've followed some of their cases for a number of years. This is lawfare at its finest.
Just to jump in, Rick, Postman represented the plaintiffs, those ostensibly California Golden State Warriors ticket buyers that were unable to get their tickets and decided to sue under the Sherman Act there. His firm was the plaintiff's firm there. They were also
and Latham and Watkins,
in other
I think,
cases.
is on the defense, as is Gibson Dunn in a ton of these cases. And so these are firms that are constantly sparring, and they're now sparring over ethical issues, over tortious interference with contract issues. Let's face it, no business, and I typically represent medium-sized businesses and small businesses, no business wants to be caught up in this. The cost is just outrageous, and nobody can afford it. Even major corporations are now walking away from arbitration. Uber, in many instances, a lot of other large firms are saying, this is just not cost effective as it was sold to us. And if we have to fight unconscionability of the delegation clause each and every time, which smart plaintiffs' lawyers are going to attack, I think you're going to see arbitration becoming even less desirable and more unwieldy and problematic.
But Rick, as you say that with businesses, don't you see that part of the problem and the difference with Heckman is that the terms for that arbitration clause permitted unilateral modification of the terms without prior notice? I mean, I don't think other businesses have such authority with their arbitration clauses.
But the arbitration providers do. Specifically, the AAA does, and so does JAMS. So what is being, quote, agreed by any consumers can be changed at any time by the AAA or JAMS or presumably any other administrator. Let's make sure everybody's covered by this. And so how is that actually an agreement? And, Angela is young compared to Phil and Russ and I will simply say I remember quite well when the AAA changed its rules to insert Rule 7, delegating jurisdiction determinations. And I still had clients with cases that predate that change in the rules. And so we've had fights in some of those arbitrations over which set of the rules apply. If you want the old rules, do you need a freeze clause? Probably do. If you get the latest, greatest rules as of November 11, 2024, well, that's what most of the rules say you get, unless you say something else applies. So yeah, that changeability, that mutability of the language exists. It may not be as bad, but I think Judge Van Dyke has said, "Hey, this is something that can be addressed." And you've got the conflict of interest issues. I mean, those are just he has a wonderful phrase where he says an arbitrator is being invited to drop a nuclear weapon on the foot of the organization appointing them. If you want to commit professional suicide, decide one way. If you don't, then you have to find that the case is arbitrable and that the rules and everything are great, etc. It's a horrible position to be placed in as an arbitrator.
Yeah,
As a
Rick,
trial judge,
after Angela had discussed the consumer issues, I did want to go back to Phil because he had some thoughts on that concurrence and on the conflict of interest part. So Phil, if you want to jump in on that, feel free. But if you could describe, since you have written extensively on your terrific website at lurieLawFirm.com about arbitrability, it is the preliminary decision as to whether the case is going to be arbitrated, and these rules in particular seem to just give that to the company. And feel free to go ahead. The company, meaning the provider and the arbitrator, feel free to describe the conflict that Rick just laid out for us.
It's actually a conflict that I know is very, very dear to Rick's heart because he and I have worked together on some cases where this issue was a similar issue has come up. That being if you've got a delegation provision and you have an arbitrator who is going to decide not only the delegation dispute but the dispute on the merits as well, then you can certainly make an argument even before Heckman that that the arbitrator has an interest in the outcome. Mm-hmm. And just as what Rick was describing, what you had in Heckman was actually the opposite of that. It was that if the arbitrator were to, not really the opposite, but a more extreme version of that, if the arbitrator were to rule, as the court did in this case, that the delegation provision and the arbitration agreement were unconscionable, that would completely destroy New Era's business models. And Judge Van Dyke was very carefully and very accurately, I thought, and for a couple of paragraphs, went into how serious a thing that was and how it would basically ruin the arbitrator's career. And there's very few human beings could resist the temptation of ruling against what they really believe, because doing so would at least ensure a future stream of income, or at least a possible employment. And so that was a big issue from the concurrence event, Judge Van Dyke's perspective. And it was the one that made me, when I first saw this decision around the end of October or something, I immediately sent it over to Rick because I just was glancing at it. I said, "Oh my goodness, this is the authority that we've waited for so long to further support this argument that arbitrators can have an inherent conflict of interest if they serve both as the arbitrator deciding arbitrability, and they would be the one also that would decide the merits." And Rick has drafted arbitration agreements where he split those two functions
right
up. and which is important. I always thought that's a darn good idea. He came up with that some years ago.
That was what I
But
was
Well,
going to
y'all,
ask
it was
Angela about.
motivated
I
by
was
James
yeah,
Madison's comment, no one should be a judge in their own case. And you have
absolutely.
too much of a financial self-interest
I was
when
going to
the
ask
arbitrator
I
decides
was going to ask
arbitrability.
Angela about drafting around that. In these guys, Angela, you and I have heard them talk about this for the 5 years we've been doing this. They want a separate panel decide arbitrability, and then it would be an equal system of justice and all that, and you would wipe out that conflict. It does seem like that they're talking about that for so long has finally come to pass with judicial notice, because I think the Circuit Judge Van Dyke is the first one that has really gone off on this in this manner. I've never seen anything quite like that. So Professor Downs, why haven't we seen a bunch of mass arbitration sets of rules and a bunch of arbitration rules with these built in? It's not like they're not out there; they are, but maybe not prominent enough, maybe not enough uptake by the users.
Maybe not enough uptake by the users. I mean, I think the goal, people want to batch these cases together, these kind of common um, offenses, these kind of common cases together. And people might not be taking advantage of that. But I think the more people realize that there's a way to utilize this and that they're getting guidance at last, from the court, I think folks would be more inclined to really implement it, because a lot of it is, as we've been saying, it's the drafting. And now we've got some specific guidance that we can really lean into, so that we can have a better product out there.
That's great. I can't imagine a setting where the institutions aren't running to their rules to look to it. And as we
Mhm.
know,
Yes.
not only from what they said, but from what we saw, that New Era itself had saw that, with the cases going on, the big high profile cases, they had gone back to it. It was kind of creepy. I mean, tying all of these cases together over years, every one of them seems to have been a moving target and have changed after the programs were implemented. Early on, I said there's been a lot of growing pains, and that's what the courts have recognized. The fact that the programs themselves have changed on the fly is a bit disconcerting, but to New Era ADR's credit, they saw there were some shortcomings and all. And hopefully in the future, they will be a little more solidified once they're in, because if not, then the postmans of the world just going to pick them apart. Rick.
Yeah, and
Yeah.
they changed their rules, but in addition to that, they actually did something that many of us in arbitration have been advocating for years, which is resolve cases promptly. And I looked at their rules earlier today, and they have a 100-day resolution goal, which nothing else in the legal system works within 100 days. Injunctions. Angela's been a trial judge. I've been a trial judge. And, we had protections against doing things involving our own interest, the Judicial Code of Ethics. One of the problems in this area with delegation has been whether it's directly to the arbitrator making the delegation determination, or more indirectly to someone else associated with the same entity. You still have that conflict of interest, but even that takes more than 100 days to resolve. So if you've got something as a consumer that you can get in and be done within 100 days, that has its own attraction. And that's something that I think may well be a positive outcome of this. One of the other things, y'all, is let's go back and look at what the U.S. Supreme Court has been doing with the textualist approach to the constitutional decisions on the Second Amendment, on Chevron deference and doing away with that, and re-emphasizing the independence of Article III courts and their, instruction to be Article III judges. Will any of that carry over to the FAA? And I think the answer to that is it's going to. And some smart lawyers, and God knows there are plenty of smart lawyers in this field, are going to raise those issues. And when they do, we're going to see some additional court addressing of the issues of unconscionability of delegation, delegability itself, who should determine jurisdiction. And I think it's going to come back to where maybe we go back to the days of when we used arbitration for specific dedicated areas, insurance, reinsurance, like Phil and I are familiar with, collective bargaining agreements. This was never intended for consumers. It wasn't intended for employment law. And it's gone way beyond what was originally intended in 1925. And if we have to look at how the Congress was thinking about these things in 1925, a whole lot of folks are suddenly going to be without arbitration.
Rick, that sounds quite fatalistic. You don't think consumer and employment programs can be made to work? The Supreme Court certainly did in AT&T Mobility
Yes.
versus Concepcion in 2010. The Supreme Court certainly did on employment in Epic Systems versus Lewis in 2018. So they're there and they are functioning.
Yeah, it's
But
funny
they have
because
a philosophic focus on textualist, and those were different compositions of the court in those days.
Yeah.
So, I mean, let's face it, you've got a very different Supreme Court now than what you had at that time. And those were not as textualist a set of decisions as we're seeing now. So, remember, in the FAA, there is a requirement for jury determination of disputes regarding the making of the agreement to arbitrate. And any smart lawyers are going to start going and demanding jury trials. And if they get those jury trials, I think you're going to be hard pressed to find any jury who is going to be thrilled about anyone being forced into arbitration when it's an adhesion contract. And let's face it, y'all, all of the Uniform Arbitration Acts and revised Uniform Arbitration Acts recognize adhesion contracts are a problem.
Yep.
Phil,
You know,
you want
yeah, I wanted to
to
add,
say where you think this is all going to go?
yeah. How about I give you one other just caveat about this whole issue of whether or not the FAA applies. Uh, one the language that the court uses talks about not only the arbitration procedures being bilateral in 1925, but there being a fair and efficient arbitration process.
Mm-hmm.
So it's kind of loaded words, and those two loaded standards, so to speak. And you could certainly argue from the opinions that that part of the FAA is supposed to contemplate, or the FAA itself is supposed to contemplate, a fair and efficient arbitration procedure, and a bilateral one, by the way.
Well, if this case were to go up, if Heckman versus Live Nation were to go up to the Supreme Court, if the petition comes in and it's accepted, do you think the court is going to go off on that efficiency? Is a day of reckoning coming on this idea of the commercial expectations of arbitration, which seems to be revised after Stolt years ago? Now it seems to be coming back on what people expect in arbitration. Or are they going to look at unconscionability, which has not been a favorite way of getting at these arbitration cases? Is the court going to focus on any of those, or are they going to just leave it all to California and decline cert?
Well, I think the court is probably going to say, hello? No, I think the court is probably going to say, if it does go up, that the FAA, the FAA is a broader application than as suggested by the concurring opinion and the alternative part of the opinion of the court, because it really, I think to make the distinction that the court has made here is just open to too much mischief in its interpretation, as Rick would say, and it's gonna end up in a lot of litigation, and because usually in terms of whether the FAA applies, it's not just. It has to do with whether the FAA applies by its terms under Section 2. Is it a dispute that relates to commerce, or so that's usually all you need. But if you're going to get into it at this kind of micro level and say, well, it's kind of an unfair provision, so it's not covered by the Federal Arbitration Act, then I don't know if the court's going to buy that.
Having sat in
and
the arguments in the U.S. Supreme Court on Stolt because I was lead counsel in 4 class action arbitrations and had won everything up until then, I watched Chief Justice Roberts questioning of Seth Waxman and thought, oh man, we are toast. And we were. So, I'm not so sure the Supreme Court isn't going to be far more textualist and careful in looking at these issues. Now, the new Congress, there will not be an Arbitration Fairness Act in the next Congress. I think we can pretty well determine that will not go anywhere for 4 years. The Democrats couldn't do it when they had both houses in the presidency. They surely are not going to do it with a Republican Congress. But we do have that focus on jury trials, and I still think this could be a real toss-up. I doubt seriously that Postman's firm is going to seek cert. So it's going to be, Ticketmaster trying to seek cert, Live Nation, and that's going to be an uphill lift. I think the court is going to say, nah, this is California. We're leaving this alone. Thank you very much.
May well be. That's what happened with the last 2 they looked at,
Yeah.
California,
I
and we could see that coming.
Yeah. And I have to
and-
agree. I think it will come. I think that it's California. They'll leave it alone and say, y'all handle it in California. We don't want to fool with it. But if it does, by some turn of events, go up, I think the court will look at the issue of unconscionability. I really do. I think
agree with
that's
that.
going to be something that they are going to focus on.
It has been a long time, so you think that its time has come for unconscionability.
I think
That's an interesting one.
Yeah, I think
Yeah.
it's a timing
Yes.
issue, and I think the time is now to address that issue.
Well, which unconscionability issue? Because unconscionability is ordinarily a state law question. But see,
Yes.
Yeah.
That's why I was saying I thought they might let it go and just say there's solid reasoning in 2 cases on procedural and substantive unconscionability under California law. I don't know what the Supreme Court would have to say on that, but if its time has come, because up to this point, Supreme Court
haven't
hasn't done
touched it.
anything on it.
Yeah.
There's nothing to say they couldn't.
No, and
Yeah.
they could determine the issue of whether or not there's preemption.
Procedural, yeah.
And preemption in a case like this on the ground that maybe the FAA doesn't apply to this particular transaction because it's not like
Yes.
bilateral arbitrations and that kind of thing.
And to bring this full circle,
Still
since
up.
we were last here on YouTube 6 months ago, the Supreme Court hasn't taken new arbitration cases, but it did turn down an Uber case and another case from
Yes.
California
Yes.
regarding the viability of the continuing Private Attorneys General Act cases in California. The court had said
Uber and
that's up to
Lyft
them.
cert
Uber
on
and Lyft,
those. Yes.
Yeah, I want to thank everyone for joining. It was a really interesting discussion. I appreciate your train spotting. I want to add, usually this would go up top, but I'll add the disclaimer. This is CPR's channel, CPR Institute, wholly owned CPR Dispute Resolution Services, LLC, which provides mass arbitration services. But it's not in the consumer area where, which is what we've been discussing about New Era and also JAMS and the AAA, whose rules, by the way, Rick, were revised by the time that Federalist Society meeting took place in May. So
Yes. That was a discussion,
presumably
and not
they
a
were
good
discussing the
one
new
for
rules.
any of the organizations.
CPR, there is a distinction between our think tank side and the business side, but the business side focuses on what they call the employment-related mass arbitration protocol, employment-related disputes mass arbitration protocol. I want to throw in a plug for the December issue, your holiday reading, everyone. It'll be on or about November 28th. The cover
Okay.
story is on what else? Mass arbitration. A shout out and a nod to our friend Matthew Adler at the Troutman Sanders firm in Philadelphia. He has written the longest cover story we've ever had in one issue on alternatives on this subject. And Matt will not be angry when I say, because of all the things we've discussed here, it's going to be out of date after the New Year's because more cases are going to come down. So I want you to read it fast. But thank you, panel, for joining. I really appreciate it. And we'll come back as these cases move along.
Thank you.
y'all.
Thank you so much,
Thank
and
you.
happy Veterans Day.
Yes.
Happy
Thank
holidays.
you to all of
Veterans
you.
Day and happy holidays.
Yes.
Thanks.
Happy Veterans Day. Yeah.
Bye.
Take care.
Bye-bye.